Testing 1, 2, 3. Okay, here we are. I can't control a lot of things, but I can control when I start the meeting. So it's 7 o'clock. We're going to get going. Appreciate you all being here. My name is Daniel Leonhardt. Today we're going to talk about how wills work, how trusts work, how they're different, what's probate, how do we avoid the probate process, what triggers a probate here in Virginia. We're going to cover a lot of things tonight. I'm so blessed to be a part of being able to share here. I speak at different churches. I've been doing this for about 22 years all over the country, speaking at churches, but also in public settings, in restaurants and hotel rooms and things like that, because the information is really important for everybody, but it's also really important for the church. We understand that our wealth is a gift from God that we can invest into heaven, when we lay up your treasure in heaven, and anything we do ministry-wise, we are really building that fund up in heaven. Just listening Sunday to all the things the church is doing, starting, in prisons and Bible studies, just with the studies. It's just so exciting to see the work that's happening through this church. We know that God has no problem with you having wealth. He does have a problem with wealth having you. So it is about priority. We do live in a land of laws and contracts, and we have assets, and assets are usually a blessing, and they can be a blessing to families. So we're going to talk about how does that work. This is all real practical stuff. There are scriptures that talk about, a good man leaves an inheritance to his children's children, and there's just different things, but basically this is stewardship, making sure that we're doing the right thing. Now, I know that, I've been attending here since 1999, so most of you are familiar. No, you wouldn't recognize me from being here. But I'm sure most of you know me from my big role in The Chosen. There I am, right there, being fed. They got my good side. But my wife and I got to spend a couple of days down there, and that was an awful lot of fun. I just say that, it doesn't matter, but it's just fun. Most of you participated in what we call financial planning, investing and watching your money grow. And then at some point you turn that to retirement planning. I don't want to work forever. At some point I want to stop working. So you maybe adjust your plan, and then that's called retirement planning, setting a date, kind of working toward that. Estate planning is neither of those two things, but it is making sure that all that we've accumulated in this world go to the right people at the right time, without courts, without fighting, without probate. That's the goal of a good estate plan. Now, I know that everybody has wishes and wants. I don't want my kids to fight, or I don't want my son-in-law to get anything. But I want to remind you, what you want and what you get is going to vary based on what you do. We have the ability to orchestrate with good documents. Basically, over the years, people have said, well, what is estate planning in sort of a line or a paragraph? And I say, well, it's the process of putting together effective legal documents so that what we want actually does take place. Again, important stuff. Some people's estate plan consists of this. Every year you say, well, didn't do it last year, going to do it this year, until next year when you say it again. And it's, every January, it's that New Year's resolution that doesn't get resolved. And what happens is, if you die without a plan, and I mean no will or no trust, that is called dying intestate. And when you die without a plan, folks, you do get a plan. It is called the government plan. And the state in which you died, in this case, the Commonwealth of Virginia, will create a will for your family after you're gone. Now, this new government written will has to go through a legal process called probate, where the assets will be tied up in the courts, and the family has the opportunity to get together and argue over the things you left. Folks, there are two things that I'm pretty sure you do not want. You do not want to send your family to court, and you do not want the government to write your will. Now, you see, when the state writes the will for someone who died without a will, you have to understand that the state does not know any of the family details. The government doesn't know that Susie already got her inheritance, and Jimmy hasn't talked to Dad in 10 years, and Barbara never paid back those loans. But you know who does know the family details? The family knows. So when they get together in the courtroom, it sometimes sounds like this. Yeah, Your Honor, this will you guys came up with? Not even close. She shouldn't get, he already got, Mom wanted me to have, and guess what they wind up doing in court? Is they wind up fighting. And do you know who wins that fight? Besides some local attorney and the state, who often wins that fight is the person that hired the better attorney. You know, Jimmy, the more clever son, hires a good lawyer, and when it's all said and done, he winds up with more of the estate. The worst part about letting the family work it out, in some cases it's worse than that, is very often the end result is they don't talk to each other. And I'm sorry, sometimes that lasts for decades because of what she got away with or what he tried to get away with. I will admit to you the do nothing plan is the least expensive plan available for you today, but it is certainly not the one you want. You don't want to go out without a plan. Okay. That being said, what can I do to prepare for my eventual departure is you could do something called a last will and testament. Now, everybody's heard of a will, and some of you probably already have a will. Let me remind you what a will is. A will is basically a set of instructions that says something to the effect, when I die, I want these things to go to these people, right? It's a distribution document. But what you may not know is your will, when you die, has to go through probate. Whether you write the will or the state writes the will for you, wills have to go before a probate court. Now, I'm going to use the word probate a few times today, and I thought you might want to know where the word came from. The word probate comes from an old Latin word. The root word was probare, and the word probare meant to test or to prove or to challenge something. Well, what is being tested or challenged in the probate court very often is the will itself. Someone doesn't like what Mom wrote, so they show up in court and they contest it or challenge the will. Now, when someone challenges a will, they don't just say, Your Honor, this isn't fair, I'm not getting enough. They usually have an angle of attack. You know, it's like, that doesn't even look like Dad's writing. I know that's not what he wanted. So I think someone drew this up after he passed. You know, maybe the accusation, it's a false document. Someone else might say, Mom was saying all kinds of crazy stuff at the end. I don't think she was mentally competent to draw up the document. So the accusation or the angle now is she wasn't of sound mind. And that's and I got friends that heard her say, great, you know, come on. So they're looking for a, you know, like a crack, you know, to go in. Someone else might say this. All of my life I was told I was getting this. I saw a will that says I was getting this, but this new document suddenly gives it to her. I think she talked Mom into changing or creating a new document, and the term you might hear is called undue influence. She was the caretaker, and suddenly a new document appears benefiting her. Bottom line is, if someone doesn't like the will, they do have the opportunity to contest it. Wills are not binding. They are a set of instructions, but they're not binding, and that's why the court can change them in the probate process. A will, by the way, folks, does not help us at all if we become incapacitated prior to death. I'm talking maybe Alzheimer's or dementia or a massive stroke or a car accident. Because, folks, a will does not go into effect until you are dead. So a will is an option. It's just a very narrow option. It only deals with distribution after you're gone. It doesn't help you while you're alive. It doesn't avoid probate. It has to go through the probate process where it could, in many cases, and sometimes challenged and changed. And even if it's not challenged, it still takes a long time and costs a lot of money, and we'll get into that later. So there is a much better option available to all of us. It is called the revocable living trust. The living trust, folks, is a legal document that allows us to transfer our assets to our heirs when we die, but it does so without courts, without probate, without delay, and most of the time, if you do this right, without the family fighting. Because unlike a will that can be challenged and argued about, the instructions in your living trust when you die are binding. When you create a trust for your family, folks, you are in essence saying, hey kids, here's what you get. Now, whether you like it or not, that's optional, but you do get this asset or this percentage or this property, and it is not subject to debate. This is what you get. This is a binding set of instructions when we die. The trust, folks, not only makes a smooth transition of assets to our heirs without courts and without government intrusion, the living trust does take care of us while we're living, because in the living trust are what we call incapacity documents. Think of the trust as a portfolio of multiple documents. There's the distribution section, the living trust, that says who's going to get and how much and who's to distribute and all of that. But within here are documents that relate to you while you're alive, but maybe unable to act for yourself. So the first document, the power of attorney for financial and legal matters, is called the general power of attorney. By the way, if you are a married couple and we were to make a joint marital trust for you, it's one trust for the two of you, but within that trust, you each get your own separate powers of attorney. You don't have to agree with your spouse on who would be the alternates and stuff. So you get separate documents, but one trust for both of you. That's typically how that would work. Now, the general power of attorney, the first of those documents, is just saying, who do you trust with your checkbook, to pay your bills, to make sure the lights are kept on. If you're mentally unable to do so, someone's got to do that for you, and you've selected someone to do that. There's another power of attorney that isn't so general. It is what we would probably say more specific or more, and that's the healthcare or the medical power of attorney. And the medical power of attorney is who would you want to interact with the doctors, consent to surgery, If you're unconscious, you can't tell the doctors, yeah, let's go forward. You can't. So someone's got to speak for you. And so you would name someone to be your healthcare or medical power of attorney. Sometimes they're called the healthcare proxy. It's just someone acting on your behalf. The person that acts in the first one and the second can be the same person, but it also could be different people. So again, they're different roles, but it could be the same person or somebody different. The third document is the advanced medical directive, and that is not who, but how would you like to be treated if you're on life support, feeding tube, respirator, and what we sometimes call end-of-life choices. How would you like that played out? I'm sure many in this room remember the name Terry Schiavo, a girl in Florida who had a very bad accident in her late 20s. She was not in a coma, but she was in what we call a vegetative state, not very responsive. She could not feed herself, so she had a feeding tube. After a while, her husband said, Terry wouldn't want to live like this. We're going to disconnect the feeding tube and say goodbye. And her parents said, hold on, we think Terry's still there. When we go in the room, she lights up a little bit. So what happened is they went to court. And in court, as you probably know, someone wins and someone loses. And the loser can appeal, and they went back to court, and they went back to court. And if you don't remember the story, they were in court for 15 years, all about the feeding tube. Do you know who eventually decided her fate? The state of Florida. Here's the point. It is not because Terry had no wishes. Terry might have been adamant about how she wanted to be cared for, but it's because Terry had not expressed her wishes in writing in time. I'm going to say something that's really true, but it's also a little blunt, and here it is. It's not going to matter what you want. It's going to matter what you wrote. Did you get your wishes in writing with witnesses and notaries? This is important stuff. So there's those three documents, the powers of attorney for financial and health, that's called the general power, the more specific healthcare, and then there's the directive, which is, think of the word directive from direction. Here's what I would want, We heard the word ventilator too much the last few years, but in those circumstances, you cannot express your wishes. The document has to do that in advance. Now, I happen to have a pretty good choice for these. I'm married to my lovely wife, Christy, for 38 years. I am her power of attorney for financial and healthcare, and she's mine. With me, right? We've selected each other. But what if my wife and I get into a bad car accident, and in the accident, I become impaired, but she dies? I now need a power of attorney. I'm impaired, but the person I selected, unavailable. I not only lost my wife, but I just lost my power of attorney. So my point to you is when you name your first choice, that is my primary choice, always name alternate A and alternate B. Why? You have no guarantee that the person you want will be there. They may be in worse shape than you. So pick a first choice then a second, then a third. Now, I happen to have some pretty good choices. I've got 4 adult children. I've got a daughter that could tell you how much money she has in every account and how much she's saving for Christmas. She's married to an accountant. All right, so if I can't be there for Christy or she can't be there for me, that's the daughter. That's the next one. I have another daughter that's a nurse, soon to be a nurse practitioner, works in hospitals with doctors all day, wearing scrubs. So for healthcare, if it's not Christy or it's not me for her, that's the daughter that would step in. So if a doctor were to say to her, hey, I need you to sign here for your dad's surgery, you know what she'd say? Well, hold on, let's discuss this. There are risks with surgery. What is the hospital's percentage of success rate with this procedure? What is this doctor's percentage of, you know why? That's her area of field. That's her expertise. So she would be a good advocate for us because she knows that stuff, right? I don't want someone who just says, where do I sign? I want someone that might advocate for me, and you need to think in that term. Who has a good skill set there? Obviously, if you have a nurse or a doctor in your family, you have a natural, place for it to fall. But not everybody does. I will remind you this, if your son is horrible with his money, he'll probably be bad with your money. So you need to think, okay, who not only is close to me, but who has the aptitude or the skill set to do this or that for me and that when the time comes. So really important stuff here. Okay. A lot of people have heard that the trust avoids probate, and that's true, but not everybody's sure they know what probate is. They've heard about it, but they're just not too sure. Well, probate is a judicial process where when someone dies, the state, through the courts, they have to verify and validate any wills or instructions that you've left to see if they're current, relevant, up to date. They have to settle family disputes. They have to pay the debts of the deceased. And when all of this is over, eventually assets do get distributed, but that's at the end of the probate process. There are 2 major misunderstandings about probate, and here's the first one. Some people think, now they're wrong, but they think that a will gets you out of probate. And here's what they say. Well, gee, I wrote it all down and it's signed and notarized. And I go, yeah, I know that's nice, but it still has to go to probate. Now, there's a lot of reasons why, but I'll just give you one. A will does not always represent the wishes of the deceased when they died. Now, we assume it represented your wishes when you wrote it. I want this and I want that. But after someone writes a will, sometimes things change, and people change their mind. I had a guy come to my meeting once and he said, Daniel, I've got a will. I wrote it 15 years ago. The will gives everything to my wife, Kathy. He said, now the only problem with that is I've been married to Susan for the last 7 years. He goes, Kathy was my wife 15 years ago. She's now my ex-wife. I said, and according to this piece of paper, the beneficiary of your entire estate. You know what the legal term for that is? Whoops. I had someone come to my meeting later. She goes, oh my gosh, you just reminded me. My ex-spouse is still on some of my accounts. I was busy getting divorced. I forgot about that. People do have out-of-date wishes. And if you don't clean it up, somebody else does. The other day, some guy goes, oh, shoot. I do have a will. I just realized I was going to war. I was 18. Everything goes to mom. Mom's been gone 30 years. I'm married with kids and grandkids, and none of them are mentioned. Well, there's a will, but how good is that, right? So wills don't always represent the wishes of the deceased. They got to go to court. So the first misunderstanding, some people think a will is enough. A will is enough to trigger probate. It is not enough to get out of it. The second misunderstanding is some people think they don't own enough. And they say, well, geez, maybe rich people, but I just have a house and some money. I'm not really wealthy. It's kind of hard to say in Northern Virginia, but the idea is I don't have that much. Well, you don't need to be wealthy to trigger a probate. Now, I use the word trigger because it's a dollar amount. And the amount that triggers probate in Virginia is different than it is in North Carolina or the district in Pennsylvania. And different places have dollar amounts that vary depending where you die, what triggers a probate. And basically the state says, if you own less than a certain amount, when you die, your estate skips probate. But if you own more than this amount, your estate triggers the probate process. Here in the Commonwealth of Virginia, that dollar amount is $50,000. 50, comma, 3 more zeros. There are cars in the parking lot worth more than that. But the point is your home is by itself is worth multiples of that. Used to be 15,000. Geez. Now they raised it to 50,000. Still catches everybody. In the district, it's 40,000. You know what you can get in the district for 40,000? Maybe a parking spot. I'm not sure. They're all quite low. Now, over the 20 years I've been doing this in different parts of the country, I've had people say, that number doesn't sound right, Daniel. I think I remember it used to be 650,000. Then it went to like 675,000. Then it went to like 1 million. And I say, yeah, I'm sorry. That is never what triggered probate. But that used to be, back in the 90s, what triggered federal estate tax, which is different than probate. Now, if you don't know what federal estate tax is, it's something like this. The government says you died with too much money, but don't worry, they're going to help you out. And then they just start taking your money. Now, when they do start taking, they start at 40%. And then it climbs very quickly to 50%. So they're just like, hey, thank you for working so hard. We appreciate that. By the way, whatever that limit is, it's not tax-free. How many times has that money been taxed? And they want another bite at the apple, right? So now that number used to be 675,000 back in 1999. You don't need to write this down. In 2000, it went to 1 million. Then it went to 1.5 million, 2, 3. 5 years ago, it was 5.5 million. Today, it's around 12 million. So I'm going to assume most of you are just under that 12 million. You do not own enough to trigger federal estate tax, but you do own enough to trigger probate. Are you with me here? 50,000, 12 million, most people live somewhere in there. Okay. Okay, so a will doesn't get you out of probate, and you do not need to be very wealthy to trigger a probate. What's so bad about it? Well, again, I have done these workshops for 22 years all over the country, all over the state of California, Arizona, Tennessee, Texas, all up and down from North Carolina, Maryland. And it doesn't matter where I am, people don't like probate. Doesn't matter the state. The 3 main things that people do not like about it: it takes a long time, it costs a lot of money, and there's no privacy at all. It's a very public event, a very public process. How long does it take an estate to get through probate? Every family's different, so every probate's different, but I'll give you the national average, 1 to 2 years. In my 20-some years doing this in Virginia, 1 to 2 years. That is common, very common. Longest probate I ever heard from someone at a meeting, I was in Culpeper, you know where that is, about an hour or so from here. Lady comes up after the meeting and says, Daniel, I'm not exactly sure how long mom's probate lasted. She said, after 10 years, I told the family I am not coming back. I'm done with all of you. You can do what you want with my share. I'm done. I'm out. She then leaned over and says, I think by then the lawyers were getting most of it. Could you imagine the legal fees of 10 years in court? Just before COVID hit, I was doing a meeting in the district. A really sweet lady comes up after and says, they tell me it's going to be over soon, but we've been 5 years in probate and nothing's been distributed. It's still tied up. Let me make this really clear. 5 years and 10 years are not that common. They do happen, but what is common is 1 to 2 years. That is more the average. But people can drag it out and make it uglier, but 1 to 2 is typical. Second problem, it is expensive to go through probate. There are the attorney's fees, court fees, filing fees, assessors. Sometimes accountants get involved. Did you know there's a Virginia probate tax? And some counties have in other words, everybody's got their hand out. The national average of what is lost in probate, eaten up, in fees, the national average is 8 to 10% of the gross market value. Virginia's a little lower than that. It's more like 6 to 8% of the gross market value. Now, I want you to hear what I said. I didn't say 6 or 8% of your equity, gross market value. That means what would the house sell for, mortgage or not? That's the market value. So that's the number you would go from. So I'm going to throw out some ridiculously low numbers. You're going to have to use your multiplication tables from years ago. Let's just say that your primary residence was just a small condo worth $300,000. Okay, that was a few years ago, right? But let's just say your primary residence would sell for $299 on the market, $300,000. Everything else you had was another $100,000, investments and antiques and whatever. So your total estate in this scenario is just $400,000. 8% of that number is $32,000. That's a lot of money your kids won't see. And that's, folks, if they don't fight. Let me tell you right now, if Susie hires a lawyer because Jimmy hired a lawyer and they go at it, I've heard a lot of stories about probate. We could talk for 3 hours about probate, but they would throw me out. But the truth is, it can get ugly, and it does get ugly. I had one guy tell me this story. He said, Daniel, I knew when we got to probate court my sister was going to lie. He said, what I didn't know is she was going to lie that much. She kept going on and on. Your Honor, this isn't fair, and Mom really wanted me to have, and I know that's what the will says, but we were having a fight back then. And it was just, he kept hearing, he said, I was sitting in the room taking it up to here. And he said, I finally blurted out in the courtroom. I said, Mom would be spinning in her grave if she heard you. That's not true. He just called her out. The judge, overhearing all this, said, would you all please approach the bench? So they all came forward, and he said, here's my recommendation, that you all go in the hallway and work something out. Because he said, right now, you are giving your mom's money to these attorneys. And he said, if you haven't noticed, these attorneys are in no hurry to get out of here. The longer we spend arguing about where it should go, that is where it's going. It can get adversarial, folks. And let me make this point. If it does get adversarial, very often it's not your kids that started the fight. It's the ones they married. It's the daughter-in-law who says to your son, how come she's getting that? Next thing you know, he's not talking to his sister, but the lawyers are. Think about the dynamics here, folks. It's money. Sometimes it came unexpected. No one was, whoa, that was sudden. Now there's money. Quite a bit sometimes. Then it's family. If that's not enough, let's throw in the in-laws. And then expectation. I thought I was going to get that. And then opportunity. And all of that is a perfect storm, not in a good way. But these are, I've heard a zillion stories about probate. Most of them start, not all of them, but most of them start with a line like this. I never thought my family would act like that. And then the story goes from there. And you know what? As believers, we're not only leaving a legacy of smooth and easy, but I don't want my kids to fight. I don't want the son and my son and his sister to not talk because of what somebody thought, they were, and kids all have their own lenses, right, of what they think is fair. Geez, Mom always liked you. No, that's just what you always thought. But point is, the truth is, I don't want to leave an argument and a fight. Look, if they don't talk to each other, then their kids don't hang out, and the cousins don't know each other, and that's a bad spiral of ugliness. When I can do something to say, no, there will be no fighting. You can be mad at me that you didn't get what you hoped for, but the truth is, I don't want you guys fighting. This is what you're going to get. Take it up with me in heaven, but that's it. You're not going to care. But the point is, I don't want them fighting. The trust is a significantly better way to make sure that doesn't happen. The third thing is it takes a long time, costs a lot of money, and that's privacy. Your will, when you die, becomes a public document, and anybody can read your wishes. Nosy neighbors, ex-spouses, disgruntled family members. But not just read your will, anybody can also contest it. Yeah. Talk about public. If you want, just go down to the courthouse, here in Leesburg, go down to the basement, and there's the wills all stacked up against the wall in giant books. They go back to the 1800s. And then on that side are the deeds. But it's very, very public event. Some of you in this room are too young to remember, but some of you might remember the name Charles Kuralt. He was a CBS reporter. He had a show years ago, On the Road with Charles Kuralt, on Sunday mornings. Well, he died about 22 years ago, and when he died, we discovered he was not alone on the road, apparently. The article says this. It says, woman lays claim to the Kuralt property. Here's what happened. It says that Charles died with just a will. As his will was going through probate, a woman showed up and said, Your Honor, Charles and I had a long-term affair, and I'm entitled to some of this. And she said, Your Honor, I can prove it. So out come the love letters and handwritten notes and receipts. We call that evidence. Today it would be text messages and emails, right? You could ask Tiger Woods or Jennifer Petraeus, I guess. So what did the court do? They listened to her claims. They looked at the evidence she presented. And the article says the court then awarded her the ranch in Montana, all the buildings on it, and other property. When I read that, my reaction was this. Why would the court do that? She's not even mentioned in his will. Remember what I said earlier? Your will is a set of instructions, but it is not binding until the court says, that's it. But in the court, it can be challenged. Well, folks, that's a lot of bad news. I got great news for you besides the great news that we all know. But in this sphere, I got some great news. You do not need to have a probate. when you get a revocable living trust, the first benefit is there's no probate waiting for your family. So instead of your assets being tied up in the court system for a year or more, literally, folks, within days of your passing, assets are available to start distribution. Folks, I mean, while people are in town for the funeral, assets can start to be distributed. Now, it may not shock you to know this, but I do have a revocable living trust. So do my brothers, so do my sisters. When I die, the family will all come to the funeral. Section 2 says they have to show up at the funeral. Just kidding. My son will grab the trust. He will go to the bank and say this: hey, my dad had $30,000 with you guys. He died last week. Here's his death certificate. And here's my father's trust. His trust says he's the trustee. Mom passed a few years ago. I am Charles, the successor trustee. That's like an executor. The bank will say, well, you prove that Daniel is dead. Can you prove that you're Charles? I mean, you could have found this in the parking lot, you know. So out comes the ID, you know. The bank turns to my son Charles and says, so what would you like to do with this $30,000? Now think of what I just said. I died last week. Monday's the funeral. And Tuesday, my son says, 4 checks, please. Here are the names. And he closes the account. He calls his sisters over and says, here's the money from Dad's Truist account. I got 2 more we'll be getting later this week. So next weekend I'll have some more for you. Hey, by the way, while I have you here, who's going to help me get the house ready? I've got realtors coming on Monday. You know why? There's no probate. There's no delays. They can start the process of distribution, get it on the market, get this going. But what if I died without a trust and I died with just a last will? Well, let's go through it. They all go to the funeral. Next day, Charles goes to the bank. He says, look, my dad has $30,000 with you guys. He died last week. Here's his death certificate. And here's my father's will. His will very plainly says, I, Charles, am the executor. Can I have the money? You know what the bank says? I'm sorry, Charles, but this account is now frozen until the will goes through probate. Because, folks, a will is not valid until the court validates it. I'll give you a hint why that's so. You may not have thought about this until now, but think about this for a second. Every will you've ever written, if you've ever written a will, says last will and testament. Nobody listening to me this evening wrote first will, second will, third will. They all say last will. How does the bank know if they're looking at the last of the last wills? There might be 2 more out there. They don't know, so they freeze the account until the court says that's the last will. But with the trust, access right away. Instead of your family losing tens of thousands of your hard-earned dollars in the cost of going through probate, whatever you spend on a trust, folks, is going to be a lot less expensive. Now, I am not going to shock you when I tell you this, but did you guys know that attorneys don't do this for free? You can go out and find a nice lawyer and sit in a leather chair, you know, and tell them what you want and get a trust made. I'll just tell you what people tell me. Daniel, we spent, and the number today is usually $3,500 to $4,500, sometimes more, but that's more or less, you know, there. And that's a lot of money, but compare that to 8 or 10% of the gross market value. You're talking tens of thousands, in some cases 100,000 versus 3,000 or 4,000. Now, we do this for a lot less than most, but the reality is, even if you spent 3,000 or 4,000, that's a great deal versus probate. Dollars and cents, just a math equation, yeah. 2 years, hassle, $20,000, $30,000 lost, or a few thousand now. So it's a much less expensive way to go than dealing with probate. And the third thing is the privacy. I mentioned your will becomes a public document. You know, when someone dies, something shows up in the newspaper like a week or so later. What's that called? Obituary, right? Death notice or whatever. There's something else that shows up in the paper a year or so later, and that's the announcement for probate. You know that part of the paper that's got the print gets really small, the legal section? You know, there's no yard sales here, but there's little, you know, the paper that gives you the basketball scores, the Stonebridge or whatever. I got one here. There's 3 of them, but this one's like an oldie but goodie. This one was in 2020, so think COVID. This is an announcement for like 9 probates. And on every one, there's a headline. It's in bold print and capital letters, and here's what it says. Notice to any creditors, notice to any unknown heirs, Notice to all persons interested in the estate of, and then there's their name. So who was just invited to probate? And if you can Google, you can get interested, I'm telling you. And then it tells you 3 facts after that general announcement. Here are the 3 facts, and then it tells you when the next probate hearing is going to be. But the facts, what are their name, when they died, if they had a will or not. So this person died in 2017 with a will. Again, this is a 2020 paper. 2018 with a will, 2017 with a will, 2019 with a will, 2018 with a will. And this person died in 1998. Without a will. 22 years later, they're still in court. Now, I did not print this paper, just so you know, and you can find this, just go to the back of any small papers, this there. But the point about it isn't that probate took a long time. Most of those were 2 or 3 years. That's not the point. We know probate's not quick. But with all of them except for one, it says with a will, with a will, with a will. In other words, the will does not get you out of probate. You can just read the paper. It tells you that with a will, there's still a probate process. So that's a mess. All right. Whew. By the way, let's contrast how public all that is. Anybody can show up, public forum. Anybody can find out who's getting how much. The only ones that get to read the details inside your living trust when you die are your named beneficiaries. That's it. It doesn't get published. It's a private document for you when you're living and your beneficiaries when you die. They're the only ones that can see it. Not nieces, not nephews, not neighbors, not ex-spouses. Only the people named have the right to see the details. This is one of the many reasons why Susie Orman, Wall Street Journal, Forbes magazine, they're telling you, you want a living trust. Modern Maturity magazine wrote this a while back. They said, if you look forward to going to the dentist or paying taxes, you might like probate. That's called tongue-in-cheek, I think. Probate is costly, slow, outmoded, sad state of affairs. Trusts, however, are a valuable estate planning tool. Anybody here familiar with Susie Orman? Maybe you've seen her on TV, read her books, a lot of you have. She just said this, regardless of how much you do or do not have, in most cases, a will is not enough. She said you'll also need a revocable living trust with an incapacity clause. What's that? The powers of attorney, the advance directives. That's what she wrote in 2004. Here's a more current article. In Trusts We Trust, I love the play on words, Susie wrote this. I'll just read you one line. Wills are required to be approved by a probate judge, but with a revocable living trust, your estate is dispersed exactly as you laid out in the legal document. And then she writes, no need for your heirs to get court approval. We bypass the courts. I'm just trying to show you the contrast. This is a significantly better option. I do want to talk about one more option. I do not recommend it, but I do want to talk about it. We talked about the do nothing plan. Don't recommend that. A will is certainly better than nothing, but it's still going to go to court, still could be contested. By far, the trust is our best option. I want to talk about one more option, and I want to talk about the dangers of joint tenancy. Most couples own assets jointly, right? Together, right? When one dies, who owns it? The other one. There is no probate when the first spouse dies. But eventually the second spouse dies. And then there's probate. What happens if the couple that owns the asset together dies together? Instant probate. There's no one on the title for it to fall to. It then has to go to court. So just so we understand the basic rules here, folks, joint tenancy does not solve your probate problem. It just postpones it till the second one passes. Are you following me, with me? Some people think they've come up with a shortcut, and here's what they say. They go, well, now that my spouse is gone and I own the house or the account just by myself, I don't want it to go to probate when I die. I've got an idea. I'm going to put my son or daughter on title with me. That way, when I die, they'll take over and it skips probate. And listen, it does skip probate, but it opens up so many other problems. In many cases, it's worse than probate. So I'm going to give you 3 reasons you do not want to own assets with your children as a way to pass the estate to them. Reason number 1, it's a bad idea. Liability. When you put a son or daughter on title of your home or bank account, folks, they are not just joint tenants, but they are now co-owners. As a co-owner of your house or your bank account, if they were to get into a car accident or their dog bites somebody or someone slips on their property and there's a lawsuit, then a judgment, what could they attach? Oh, anything that they own, and they now own half of mom or dad's estate. Whew. Imagine a few years ago you put your daughter on title. She now discovers her husband, your son-in-law, didn't take the vows too serious. He's cheating on her. She throws the bum out. They divorce. In the divorce settlement, half of what she owns goes to the ex. I just said 25% of your equity just left with your ex-son-in-law, and you wanted to give him something else. But the truth is, that's what happened. You gave him 25%. Why? Because you gave her 50% when you put her name on title. And then that got split. That's just reason number one. Their problems become your problems when you commingle the assets. Reason number two, it's a bad idea. Distribution. Let's say, I don't know, I got to come up with somebody here. Let's say that this row right here are my three children. This is my son and you're my daughters. And I make a deal with my son. Look, mom's gone. I don't want the house to go to probate. Let's you and I own it together. Now, when I die, I would like you to sell the house and share it with your sisters. And he says, okay, Dad, I'll do it. Here's the question. Does he have to? No, he got a house and the girls got disappointed. I'm going to tell you right now, I'm sorry, but brothers cheat sisters and sisters cheat brothers. And they somehow justify it. I guess Dad knew I needed that house. No, you didn't do what you said you'd do. And guess what? Deceased father cannot make him sell. Neither can his sisters. I had a plan. It was just a lousy one. And that's a plan I couldn't enforce. I died and he wound up with the house. Ouch. That's reason 2, distribution. Here's reason 3. I don't care if you have multiple heirs or one heir. Let's just pretend it's one heir. You're giving everything to Barbara, your daughter. So you put Barbara on title of the house. You die, now Barbara owns the house. When she goes to sell that house, she has to pay capital gains tax all the way back to your original purchase price. So imagine you bought your house 20 years ago and paid this, and 20 years later it's worth this. That's called a capital gain, right? Let's just make the math easy for the speaker tonight. Let's say 2 decades, 200,000. I know that was just the last few years, but let's just say 200,000 over 20 years. Do you know what 20% of 200,000 is? $40,000 to the IRS, capital gains tax. But listen to this, none of that happens when you pass it through a trust. When you pass your estate through a living trust, listen, your children are not co-owners, they are beneficiaries of your trust. And as beneficiaries of your trust, there is 0 capital gains tax due, none, 0. I don't care if you paid $200,000, it's worth $800,000. They get the property through the trust at the current value. It's called, if you want to know the CPA term, a stepped up tax basis. The IRS doesn't care what you paid. What's the value when you died? That's the value it transferred to your children. But folks, that's not just on your primary residence. If you have a second home, a vacation home, a rental property, an investment property through the trust, that also gets a stepped up tax basis, no capital gains. What about stock that you bought 30 years ago at $20 a share that's now trading at $120 a share? That also gets a stepped up. So everything in the trust gets a stepped up tax basis. No capital gains. No distribution problems with my trust, because if my trust says third for my 3 children and I die, you know what the trust says? Third. It's not negotiable. It's not contestable. Look at the words here, folks. Revocable living trust means while you're living, you can do what? Change it. You can revoke your previous instruction. But when you are no longer living, the trust becomes irrevocable. And do you know what irrevocable means? Cannot change it. So I often tell people, if you do not like what your parents wrote in the trust, when they die, you will have the right to be disappointed. And that's it. Can't change it, because when they die, that's set. And listen, I would rather be the one that decides what's fair than them decide, because that doesn't always work out. Look, I will decide. I know these are our assets. We get to decide what's fair. How much do I want to give to ministry? How much do I want to give to church? How much do I want to give to each of them? I'll decide that. I'm not going to let them decide. So the trust when I die is mine. But while I'm living, I could still adjust it or change it. When I die, those things are set. And the last thing is liability. Just because I have a trust today does not mean my daughter cannot divorce her husband. Sure, she could. It doesn't mean my son couldn't drive too fast, lose control, and injure somebody with his car. Those things could happen. But if those things happen today, those things will affect their estate, not my estate, because we did not commingle the assets. Are you following me? So there might be another way to avoid probate, but it comes with so many downsides. With the trust, it's, hey kids, here it is, come get it. No waiting, no courts, no fighting, no taxes. Just a zillion times better. I want to tell you a little bit about having a trust made by an attorney versus doing this on your own. I do want to tell you there's some options into getting a trust. And I do want to say, if you have questions, please write them down. We are going to stop at the end for questions. So I hope I'll have covered them. But if I haven't, I want to make this really clear. So we are going to stop for questions toward the end. So one option is you can find an attorney on your own and pay them whatever they charge. And, whether it's $3,000 or $4,000, you got a trust made, that's good. But as you may or may not know, most attorneys charge you every time you pick up the phone, right? They're very, if you haven't worked with lawyers much, you may not know this. Most of them are very transactional. Have you heard the term billable hours? It's billable tenths of hours or whatever. But the truth is, what happen is I've had many people say, Daniel, I spent $3,500 on the trust, but every time I call the attorney, it's another $150. So then they say, guess what I don't do anymore? I don't call the attorney. I'll Google, I'll guess, I'll wonder, I'll talk to my neighbor, but I ain't calling the lawyer because I don't know what that's going to cost. That's a shame. You spend a lot of money with that firm, but you don't feel the liberty to pick up the phone. What we do is give every one of our clients a lifetime of ongoing consultation. There is no bill in the mail. If you have a question, pick up the phone. We will talk to you. We get phone calls. Some of them say this, hey, Daniel, you may not remember us, but we got a trust from you guys about 9 years ago. We're thinking about moving to Colorado to be closer to the grandkids. Does the trust we made here in Virginia work in Colorado? And we say, yes. Once the trust was signed and notarized, it's good in all 50 states. You don't need to make a new one just because you cross state line. And the client goes, good to know. Another call. Hey, Daniel, my mom passed away. I'm inheriting a piece of property from South Carolina. How do I put the South Carolina property into my Virginia trust? And we say, just tell the title company you want to take ownership as trustee of the Smith Family Trust or the Donna Smith Trust or whatever. So we tell them that, and they say, that's all I need to do? We go, that's all you need to do. But my point is, if you don't know, you don't know. We give our clients a lifetime of support. Don't fear the phone. We say, use the phone, talk to us. Most of you are not going to change your trust a lot. Kids are out. Okay, you're back in. If you do that, change your medication, not the trust. The truth is, you can change it. You're just not going to change it a lot. I mean, you're not going to, but when you die, it is set, and that's when it's set permanent. So, okay, so you can go to a law firm and pay them whatever they charge. Let's go to the other extreme. You can you can go to Staples and buy a kit, fill in the blank, or go to LegalZoom.com and create your own documents on the intranet. You could do that. The problem with the kits, whether they're online or paper that you bought, is there's no attorney guiding you, helping you, answering questions, double checking your work. No, it's you with your law degree creating a complex legal document that you hope works. And by the way, if it doesn't work, you won't be around to see how it turned out. You're gone. I do not have to say anything bad about LegalZoom, so I won't. But I will tell you what LegalZoom says about themselves. These are their words. I know you weren't thinking about it, but your friends were. Here's 4 quick points. This is just general information that they put on their website. LegalZoom disclaimer. LegalZoom is a document service and not a substitute for the advice of an attorney. LegalZoom is not permitted to engage in the practice of law. Therefore, you will get no advice, explanation, opinion, or recommendation. If you're doing it wrong, they can't stop you. It says LegalZoom will not review your answers to see that they're legally sufficient. But I love this one. LegalZoom cannot guarantee that the information on our website is current. So if you're comfortable with that, it's an option. But we think, folks, that's a very, you're putting a lot of eggs in this basket. You want this to be well made. Having a trust is important. Having it well made is also really important. So briefly, who are we? We're not the expensive law firm. We're not the kit. We're a company that uses great lawyers to make great documents. When you do work with an attorney, I want you to know, You want an attorney that does this for a living, not just someone that passed the bar. President of the American Bar Association made this comment. He said, any attorney can write you a will. He said, they all learned that in law school. Your local real estate attorney could write you a will. But he said less than 1% of attorneys have ever made a trust. And then he added, let alone a good one. So you want a good trust attorney, not just someone that passed the bar. Simple analogy is, if I ever need heart surgery, I want you to know I'm not going to the ear and nose and throat doctor because he's closer. I'm going to find a heart surgeon. Well, geez, Daniel, they all went to medical school. I know, but I want the one that works on the heart. All lawyers go to law school. You want a lawyer with experience in doing trust. This is a very unique field. You want someone that knows what they're doing. All right, let me talk to you about the conversation with an attorney on the back and forth the attorney would have with the client. And again, every client's individual, every person's individual, but this is going to help you understand some of the nuance of why this is an important and unique document. The attorney, might say, hey, how you doing? Let's talk about the details. They don't assume you went to law school, so they're going to talk in plain English. And it might sound like this. Tell me, when you die, do you want everything to go to your children? Do you want it to go equally? Do you want to give some assets directly to grandchildren, sort of a grandparent gift? What about churches or charities or, ministries? What any other options there? Do you want everything to go from your trust to your heirs as soon as you die? Or would you want to leave some assets in your trust for years after your death to fund your grandkids' education or maybe great-grandkids? What a lot of people don't know, and it's just because they don't know, but you can leave assets inside your trust if you want up to 70 years after you've passed away. Yeah, I do not remember my great-grandfather, but if he left me money for college, I would remember him fondly. We have a dear friend of ours, graduated from medical school about 7 years ago. He's a doctor now. He graduated medical school with zero debt, one of the few in his class. How did he do that? Well, his grandfather created a trust, and his grandfather's trust said something like this. This is an incredible paraphrase. Hey, grandkids, listen up. There's money over here, but there is no money for trips and motorcycles. It is for your education. And he said to his grandkids, go to the best school you can get into. I am your scholarship. He said, I have not talked to my grandfather in 15 years, but I thought about him every time my tuition got paid. You know why? Grandpa thought about me. And he said, being debt-free means I could move to any community I want and not worry about those bills. I can move to the country instead of have to be, it gave him freedom, that's freedom. Anyways, so cool ideas, different ideas. Trust can hold money for a lot longer after you're gone. A good attorney knows that we cannot just make a plan, but we must help you develop a backup plan because we don't know how it ends. It does end, right? But who dies first, who dies second? We have to think about contingencies. So the attorney might say this, I see you have a son and a daughter and you want them each to get 50%, no problem. But what would you want to have happen in the event you died with your son? Going to dinner, car accident. Would you want his share to go to his sister? Or would you want his share to go to his wife? Or would you want his share to be kept in the trust for his children, your grandchildren? And then one more question. If it goes to the grandchildren, when do you want it to go to the grandkids? When they turn 18? Well, you can do that, but they won't have any money at 19, right? How about 25 or 30? Someone the other day said, keep going. But the truth is, if you say where, but you don't say when, you know when is? 18. You know what an 18-year-old does with inheritance? Woohoo, college, who needs that? 2 years later, the money's gone and so's the scholarship. Why? Because someone didn't say when. We just think 25 is better. Now, you can pick whatever you want over 18. You can pick, but at 18, they don't know what bills are, right? They lived under someone else's roof, Hopefully at 25, they're not under someone else's roof. But at least they've learned a little bit, right? So we just think that's better, but you get to choose. But my point is, someone needs to bring that up or you won't think about that, right? So we're trying to help you think through the things that can happen, not just things that will happen, but the possibilities, not just the probabilities. That's important, contingencies relating to that. Now, Thanksgiving might be a reminder of this, but in families we have people we love and there are people we tolerate. And some people tell the attorney this, hey, I just want you to know right off the bat, I do not like my son-in-law, don't like the way he treats my daughter. This money is not for him, it's for her. And I want to be really clear in the document that this money goes to her, but if she's not there, it goes to her children, but not her spouse. And the attorney will say, not a problem, we can exclude the son-in-law or the daughter-in-law. But a good attorney says, I got one more question. When you say you want your daughter to get her share, but if she's not there, it's to go to her children. When you say her children, did you mean biological children? Because what if later in life she remarries someone who has 3 kids from a previous marriage? She did not raise them. They were out of the house when she met their father, but those are her children. They're called stepchildren. Just as a reminder, stepchildren are children, adopted children are children, foster children are children, biological. Are you following? We want to define the terms. I had a lady the other day said, I've never met my son's second wife's kids. Why would I consider them the same as the ones that come every Thanksgiving? I said, apparently you don't. we better make this go to the right people, right? So precision language, gets precision results. Very important. So let's say I thought, well, I'm not going to use a lawyer. I'm going to grab a kit, and I'm doing a kit and it's fill in the blank. And I go, I go to the expert, honey. There's a blank spot and it says special instructions. What do you think? Let's leave some money for the grandkids. I heard that at a seminar. Let's go, I don't know, it's not going to be much. $70,000 set aside for the grandkids' education. Okay, so we put that in there. I die and my grandson discovers there's money in a trust for his education. You know what he says? Woohoo, I'm going to jet ski school in Florida this summer. Well, that's not what I meant, but it says education and he wants to learn how to ride a jet ski. It's called C-Do-You or something. A good attorney would say this, Daniel, when you say the word education, did you mean an accredited college, a university, a trade school, a law school, a medical school? And I go, well, yeah. He goes, well, we better write that because if we just say education, it could be Joe's fishing school. I would frankly put a clause that says, if I'm gone and you've got kids that are at the age that could go to a private Christian school, this money can go for that, not just higher education. I think we all know higher education isn't so what it was cracked up to be. My point is, you can create different scenarios and give different parameters of distribution. So this is a great tool for that. So this is where lawyers that know how to do this are asking the right questions so we create the right documents. Very important. It's not natural to think of the death of our kids. We should die first. That should be the rule. But sometimes children die before parents. We have to have a plan for that. We don't build a good trust based on the hope or the best of scenarios. We want to create a trust that will work in all scenarios. So that's why we'll ask the next question. And if they're not there, and when would you want it to go? Things that we hope never happen, but can and do happen, we want to have a document that prepared for that. So this is really important. So when my trust was made 23 years ago, all of my kids were under the age of 18. So I have a section in my trust called guardianship, somewhere in here, right? Somewhere. Guardianship. That means, what if we die while the kids are still minors? Who's going to, and us as believers, we want people that have the same beliefs, right? The belief system that are going to raise the kids in the same manner that we were trying to raise them in. That's important. But if you don't have that, the government will decide where your kids will end up. You want to put your 2 cents into the document. I would prefer this couple or this family, and if not them, then the second pair. We're going to ask you for 2 if you have minor children. This is really important, and this is part of the trust if you have minor children. Now, my sister has a trust, so do my brothers, I said that, but my sister has a daughter, my niece, that is 50 years old and still needs a guardian, because she's 8 years old here, special needs, And for the last, few decades, she's been getting what's called an SSI check, government assistance because of her disability. If I were to give an inheritance to her, hey, Deborah, here's some money from your Uncle Dan, you know what the state does? They take it. They go, thank you, Deborah, that's reimbursement for all the years you've been on government assistance, and she never sees her inheritance. Or the state says, hey, Deborah, now that you have this money from your uncle, you don't qualify for SSI because it's needs-based and you just came into this money. So the checks she's been getting for decades stop. Neither of those is a great result for my disabled niece. So what we will do for our clients, if you have a special needs family member, we'll create a special needs provision. I think I've got it up here somewhere. There it is down here. A special needs provision. This is like a little trust inside the trust. When I die, the other assets go to the other heirs right away. Homes are sold, money is divided to the others. But the money I left for my niece would stay there. And every month after I'm gone, she gets a little until it's gone. That money, folks, over the next few years will supplement her checks, but not jeopardize them. Isn't that better than losing the money? But how would you know unless someone said, you can't do it like that, but we can do it like this. And this is why we have lawyers in the process. Very good. Let me get one more section done, and then we're going to hit questions. So I just have one more important thing, and then we'll do that. I mentioned the trust can distribute as soon as you die. I also mentioned the trust can hold assets, up to 70 years. So let me give you some ideas that might be practical, might make sense, may not. It's your family. I have grandsons. I've got granddaughters. Let's just say I wanted to give my grandson $20,000. I could say, hey, Jordan, I've set aside $20,000 in the trust for you. The week that I die, the successor trustee will write you a check. Have fun. Remember Grandpa. Drive careful. No strings. There's 20 grand. But I could also write that like this. Hey, Jordan, I've set aside $20,000 in my trust for you. Now, in order to get the $20,000 after I'm gone, all you're going to have to do is show the successor trustee a diploma from a college or university with your name on it, or you turn 30, whichever comes first. Now, what have I done? I've just given my grandson 20,000 reasons not to quit his junior year, right? In other words, it's called an incentive provision. I'll give you this if you'll do that, right? And you can do that or not, but I'm just saying it's an option, right? One lady had a different incentive. She had a will only, $300,000 estate, not huge, but it was all going through a will to one heir, her son. The problem is her 36-year-old son had been struggling with drugs his entire adult life. And her fear was after probate, he's going to have $275,000 to spend on drugs. Bad idea. So she puts the money in the trust, and the trust says this. Son, I assume after my death you're going to want some of this money. Here's how you can get it. The week that I die, and every 6 weeks after my death, you will be drug tested. The results will be given to the successor trustee. If those are good results, they will write you a check. If those are bad results, you will hear these words. Come back in 6 more weeks with better results. She said, I did not accumulate this wealth to feed your drug dealing friends and your drug habit, and I won't. Now think about this as believers. The money that we've been given is the Lord's money that we're entrusted with to enjoy and to funnel to other great places to grow the kingdom. And it's awesome. When you die, you're not going to need the money anymore, right? I'm just encouraging you to think, hey, what a neat, my kids know that some of the estate's going, not to them, but it's going to go to ministry. You know what? They saw us tithe all of our lives. They're going to see us tithe in our death. And I'm just saying, it's much better than the example I just gave you, someone giving your money to the local drugstore or a local drug dealer or a liquor store or something. So again, I pray that that's none of your family, but it is out there. You can direct and put rules to distribution so they go to the right people at the right time under the right circumstances. So the trust is a great tool for that. So that's one thing. Now, I had one lady say this. She goes, I got all the reasons to do this. I've seen families in court. I know what probate's about. It's often a lot of fighting. She goes, I don't want any of that. She goes, but I have another reason to do this. She says, I happen to have an incredibly lazy son. She goes, I don't know what happened. Everybody else got the work gene, but he didn't. And he plays video games. He's happy with the sandwich. She goes, I'm afraid when I die and he gets more money, he's not going to be more motivated to work. He'll be less. So we wrote this in her trust. Son, after my death, you're going to receive from this trust every year exactly the amount of money that you earned the year before. So if you work part-time at Dunkin' Donuts and make $6,000, $6,000's waiting. If you make $40,000, I'll double your income. But you got to go do something. This is not sit around and collect. So I'm just saying you get to write the rules. These are your families. These are your assets that the Lord gave you. Decide how you want it to go. But you have a lot more control of distribution this way. It gives you a lot more control. Okay, last subject, but very important, and then we will stop for questions. The way that a trust avoids probate is simply this. The state of Virginia, the Commonwealth, says if you own more than $50,000 when you die, your estate triggers probate. So how do you avoid probate? Don't own more than $50,000. Let your trust own your assets for you. So when my wife and I signed the trust, we then signed a transfer letter telling the county to change the deed. The deed of our home went from Daniel and Christy Leonhardt, the owners, to Daniel and Christy Leonhardt, the trustees. It is still our name and still our house. Who lives in that house? The trustees. Who pays the taxes? The trustee. Who pays the mortgage? The trustee. Who mows the lawn? Trustee's son, if I can get him over there. The truth is, it's my house in every way. Can I sell it? Tomorrow if I want. Can I refi? Done that a bunch of times. The point is, it's your home in every way, but you're not an owner, you're a trustee. And as a trustee, it doesn't go to probate. But if you continue to own your house after you create a trust, it will go to probate. You're the owner, it triggers a probate. So assets need to be transferred into the trust. It's called funding the trust. So when our client signed the trust, right there we have a transfer letter that tells the county to change the deed. And it says you are the grantor and the grantee. That means it's still you. You give it to yourself, but you're not an owner, you're a trustee. As a trustee, you can do anything. The house that I put in 2001, I sold. Bought another house, sold it, bought another house. It's your assets. Think of the trust in the same way that you think of a safe. If you buy a really nice safe and you put something in it, is it still yours? Can you take it out? Can you put something else in there? Yeah. The safe is just the housing protecting your things. The trust is just the housing protecting your things. But if you leave something out of the trust, it goes to probate. So I want you to know the trust needs to have assets in it for it to work. I did a meeting, down in Richmond. It was Midlothian, but this lady said, Daniel, my father had a trust. He paid like $3,300. When he died, I had to take everything to probate. It took a year and a half because nothing was in the name of the trust. He signed it. He threw it in a drawer, but he didn't understand that assets had to be in the trust. He didn't understand that part. See, the trust needs to be the entity that owns the assets. That's good. So we're going to do that for every one of our clients that signs the trust. Right then, we sign the transfer letter, and then we go to the county recorder for them. They don't have to go, and your house is in the trust. And the next time you get anything from the county, it'll say, like mine, Daniel and Christy Leonhardt, co-trustees. The county acknowledges the trust. But it's ours in every way. Sell it, buy another one, refi, all of that's the same. The checks and the checking accounts in the trust. I still write checks now and then. I still slide my card at Subway and they give me a sandwich. Where'd the money come from? The trust. It's your money though. You spend it all. No one controls it but you. Today, no one controls it from you when it's in a trust. Think of it like a safe, but you got to put assets in. Very important. Once your house is in the trust, and again, there's just a couple more things. There are other assets that need to go in. So the client says, what about my checking and savings? And we say, here's the piece of paper that you show the bank. They'll now know there's a trust established on this date, and they will make your accounts trust accounts. You're not getting new checks. The debit card still works, but the bank acknowledges that account as a trust account. So there's something you must show the bank. And then most people say, well, what about this? I got a 401k or an IRA, and we will say, we cannot retitle your IRA into the trust today. If we did, the IRS would make you pay all the deferred taxes this year. So we're going to tell you that some things need to go in and some things cannot go in. The things that cannot go in today, IRAs, 401ks, insurance policy, maybe a government pension like a TSP, those things will stay in your name. But the things that stay in your name have beneficiaries. Are you with me? It's going to someone, not going to probate, it's going to these people. We're going to recommend you change the beneficiary to the trust. Send it through the trust. Now, if you're married, let me make this clear. Your spouse will always be the first beneficiary of a 401k or an IRA because there's tax advantages to keeping the spouse. But the contingent beneficiary, that means after the spouse, should be the trust, not the children. Now, you might say, Daniel, I already have my spouse and my kids on there. Why do I need to include the trust? Great question. Now I'm going to tell you why. Let's say that the four of you are my four children, I'm the dad, you're the kids, my wife, your mother has passed, and I have a $400,000 life insurance policy, and you're all named as beneficiaries. Don't worry, they're not really. But anyways, they're named as beneficiaries. 100,000 each. I now made a trust. I should change it to the trust, let it go through the trust, but I didn't. Now my son and I are going to dinner one day, car accident, we both die. Where's the money go? To the remaining beneficiaries. And I just disinherited his children. But if I name the trust as the beneficiary, what happens? 400,000 goes to the trust. From the trust, it goes to my 4 heirs. But my trust says if my son is not there, his share goes to his children. They still get their 25%, but his is split. You follow me? And because it goes through the trust, it doesn't get to his kids at 18, because the trust says nobody gets it till they're 20. Are you following me? It's better. It knows what I want. Let me give you one more reason. Don't worry, you all survived this one. Dad, 4 kids, $400,000 life insurance. I should name the trust now that I have one, but I didn't. And I left the 4 of you on as beneficiaries. I die, you each got a check for $100,000. She enjoys the money, he enjoys the money, he enjoys the money, but you do not. Why does your sister not enjoy her $100,000? She's in the middle of bankruptcy. Anytime she gets any money, it has to go to those creditors. Not as much fun as the other 3. But watch this. If I name the trust as the beneficiary, 400,000 goes to the trust. The next day, the other 3 will go to the bank and get the money and book their cruise or whatever. But the other daughter is going to say, I don't want my money right now. I'm going to leave it in Dad's trust until the bankruptcy's over. I'll take it in a few years with interest. Or, in some cases, I'm going to leave it in Dad's trust right now. I'll take it when my divorce is final. Does anybody want 100,000 showing up in your name in the middle of a divorce settlement? I don't think so. My point is the trust gives your kids some options. It gives them some creditor protection, but not if you don't use it. Are you following me? So we're going to advise you. There's no downside of sending it there. There's some upsides if those things happen. Remember, we're not trying to build a plan for the best case scenario. We're building a plan for all scenarios. We don't want what we wanted to not happen because we didn't think it through or didn't use it. So the trust is a great tool. One last thing, and I'll take some questions. For those with kids, you got about 5 minutes before they're going to want you to go. This is not my personal trust. My trust's at home. But this is what it looks like. This is what, our client's trust looks like. But imagine this. I'm driving down the road one day. Geez, I get killed a lot. Boom, I get into a car accident. I'm not dead yet. I'm taken to an emergency room, unconscious. The kids show up and say, how's Dad doing? Doctor goes, well, he's stable, but he's unconscious. We need to do surgery. Which of the 2 of you has the power of attorney for healthcare? I need someone to sign off. There's risks and all. And my daughter says, yeah, I think that's me. And you know what the doctor says? I think that's not good enough. You have to prove that it's you. So you know what the kids have to do? Leave the hospital, go to my house, and try to find them. Geez, where does Dad keep this stuff? It's as messy as when I lived here. Oh, great, there's a safe. Do you know the combination to Dad's safe? Because I don't. I kind of play out that little drama for this. What if you created these documents, spent the time and the money and the energy to do it, but when you need them, they're not there? With us, we create a card for each of our clients. If you're married, you each get one. And it says emergency access to my medical directives. And this card goes in your wallet. And before they can, they don't know who to call yet. You're coming in off a gurney. The nurses at the nurses station will, through this card, not only know who is your medical power of attorney, who's the alternate, and phone numbers to reach them. It will also tell them that you're allergic to penicillin or sulfa medication. It will tell them the name of your primary physician and phone number. It will tell them any medical condition you have, like diabetes or asthma. It will also give them the HIPAA release, you know what that is? So they can speak freely to family. But not only that, before they roll you into the ER, the nurses at the nurses station will go to this website, punch in this code, and right on the computer at the nurses station, they will see your powers of attorney and your advance directives signed and notarized, and they'll print them right there. No one needs to go home and get them. They were in your wallet the whole time. This is just some of the stuff that we offer, but this is educational today. Let's get some questions in Boy, let's start over here and work our way. Let's go with you. Yes?
Is there an app for that? Because I don't think anybody carries cards anymore. At least the younger generation, right?
Yeah. Take pictures of it. Send it to your kids. They'll have a copy of it as well. That'll be on their phone. It is just numbers and, so it's not like a magic card. There's nothing to go, whoop. It's all just information here that accesses a cloud. So that's it. That's an option. Yes?
Successor trustee, they're responsible for ensuring that the trust is executed when it's done, right?
Yes.
So how do you help ensure that the successor trustee is capable and willing and completely unqualified to do the job that you've asked them to do?
True. His question was, what if I name a successor trustee and they don't want to do what I've said or they don't know how to do it? They're not qualified. Well, obviously you should pick someone that you think would do a good job. First choice, right? But, you have to decide these things. But, okay, here's someone that I think, has skills and aptitude. Another option is name someone to work with them. If your kids are relatively young, maybe you have a brother or sister can be a co-successor, meaning they work together. It's like a joint. So that can be the case. If you really don't have the confidence that your kids might be able to do this, or get help to do this, you can name a corporate trustee. It's a bank or an institution that will act as your successor trustee. So there's that option as well. So, obviously pick the people that you might think are the most qualified within your family, and there may not be many. And if that's the case, you can then inquire who does a good job with this. Some, big financial houses, Vanguard, and these others do those things too. So there are there are other options. Yes? Yeah. Well, I can't speak for every firm, but what we do is we give all of our clients, when they decide, yes, I would like to do this, we give you all the questions in advance so that you know what the attorney is going to ask you, so that you're not getting thrown curveballs. Gee, I didn't know that. Kathy, no, Susan. Geez, you go home, you go, I should have said Barbara. She works at a hospital. We give you the questions in advance, so before you're talking to the lawyer, you're looking at the questions and you're saying, honey, I know we were talking about John doing that, but maybe John and Kathy could do that together. So having the questions will prepare you for that. But one of the things that we do to make it really smooth is we let you change your mind all throughout the process. Even after it's printed, you can change your mind. Even after it's signed, we give every client a year to change it. So there's no harm to adjust it after it's signed. That's a way to make you feel comfortable with your decision. Do the best you can with the knowledge you have. And then if you change your mind, we give a full year to adjust it. So somebody else, yes, here. And then, it's hard for me to do this, so I'm going to get her, then I'm going to come to you, then I'm going to work my way this way. So let's start with you. Great question. She's asking about what about fees after the fact and stuff. I can speak for us. I know a lot of attorneys, every time that phone rings, there's another money opportunity. When we set a price, we say that's the price that we charge our clients. It's a lot less than most. It's just a little over $2,000. But it's everything that you've heard today and more. But we also charge $150 to put the deed in. So we do the paperwork and the legwork to the county. So we charge $150 for that. But there's no more fees. That's it. The county recording fee is a little, $45 or something. What we do in order to help you with changes, and it's an option, I can tell you what we do, is we give every client a year for free in what's called our legal plan. It's a 1-year enrollment. It comes the day you sign your trust, you get this 1 year. And that gives you changes and amendments to the trust and access to more than 15,000 lawyers in every area of law. Real estate attorneys, tax attorneys, elder law, injury, anything you need a lawyer in the next year, you'd have that through our program for free, consultation, letter writing, whatever. Every client of ours has the option to renew that legal plan after the first year, and we charge $125 a year. So some do, some don't. Most do, but not everybody. So it's an option to stay. It's like a reduced cost to have that covered. But that's, again, your option. I know many law firms, they don't have that option. Every time you call, it's in every change. So, but you have to weigh that out. Find a good attorney. If you don't, work with us, get somebody. Okay, I saw this hand here, and then I'm going to go work my way across here. I see you after. I'll keep doing my best. Yes?
All right, so when you talked about the four siblings over here with the life insurance policy, so if you name the trust as the beneficiary of life insurance policy, then it can be...
Yeah, this has all the plan here. Send it to the plan.
And then, so with the Roth IRA and the 401k, that you can't do until after death, but you can still make stipulations of how that money is used within the
You can always send it through the trust. If not changing the ownership now, send it as beneficiary, yes. And what we do is a lot of people wind up go to a lawyer, get a trust, and then they don't know what goes in it, how does it work, what about a 401, and they're kind of lost. And then they go to their account, their financial guy, and he doesn't necessarily know. He goes, well, you can't put your IRA in there. Well, he didn't tell you could make the trust the beneficiary of the IRA. You know, so we have with every client a financial advisor that advises you on how this goes and what happens. That's again, I only speak for. Yes, ma'am. In most cases, yes. 98% of the time, one trust works for both. Even in a second marriage with his and her kids, that can be very easily accomplished here. There are some clients that have had everything separate, all of their, married late in life, his kids, her kids, none of kids together, and they want to keep it separate, then two trusts are totally appropriate there. But we can work it out with one trust. The attorney would be the one that would really walk you through the pros and cons of doing one, but most we can do it with one for the majority. Yes? Yeah, sorry. Yes. Right.
So, first my question is there an annual fee then to keep the trust going, or does that just depend on if there disbursements are being made? Like you gave some of the examples in terms of people who have these certain conditions and stuff.
Here's the thing: when when you die and there's still money, assets in the trust to be distributed over time, like grandkids' education, somebody has to pay the taxes that would be due on the growth of the money in there. A tax, EIN number has to create, anyways, a tax form. While you're alive, you don't have to do a different tax form. You do your same one you do now. The IRS doesn't care that you have a trust while you're living. It's when you die, this is a separate entity, you're gone, your social's retired, so then there's a new EIN. Somebody has to manage the trust and they get paid for that. It's called due compensation. There's money for the time I spent to do all that stuff. But there's no like fee. It's just somebody gets paid to do as you've instructed.
So would that be something done so that your company?
Yeah, it can help. Yeah, and say, here's a reasonable fee for this, and you need to pick who you'd want to do it. And we could tell you what an outsider would charge, a corporate trustee, and you can weigh that off that. Sometimes the corporate trustee is this or that side of 1% of the estate. That's not that much compared to probate, to have somebody else making sure it goes to the right people. So, you guys would have to weigh that out. I saw some more hands over here.
Would you recommend if someone were to do a trust for property that is set up with transfer upon death?
Yeah.
Putting that in the trust, or is it?
I would recommend that. The trust is just a better option. There's something called a transfer on death deed, which is available. Problem is, if they're not there, it goes to their estate, which means probate. It can't go to their children, so there's no alternate option. There's a lot of downsides. The lawyer can discuss it with you. It's limited. It's for the very simple, I only have one child and this is all it's going and that's the only asset. But we wouldn't typically recommend that. It's a rare case that is a very good option. Because there's just not a lot of life. We don't know what life holds, and it doesn't give you very many options with that. In the very back, yes, ma'am.
Yes, listening to all of this, it makes me think that you would do this for votable trust and there wouldn't be a circumstance you would want a will.
Oh, I'm sorry. Yeah, that's a great point. There is a will within the trust. It's called a pour-over will. So when you have a trust, you also get a will in it. You don't need to go then get a will. There's a will in the trust. And the pour-over will says basically this: anything I may have inadvertently forgot to put in the trust, I still want it to go to these heirs in this manner. However, if the trust... I'll give you an example. I was doing a meeting in Fredericksburg a while back. This lady said, I know what you're saying is true. My father died with the trust. His house was in the name of the trust and so were his accounts. She said literally within 2.5 weeks of Dad's passing, the money was divided, the house was on the market, and realtors were bringing clients. 2.5 weeks. She said, but my father had another property, a rental property in Fairfax County, he forgot to put in. She said that property went 22 months in probate. 2 weeks, almost 2 years. What was the difference? One was in the name of the trust, one was not. The pour over will would say, even though this is going to probate, this other property, I still want it to go to these heirs in this percentage so that if there was a son you were disinheriting, and I don't mean because of falling out, maybe an early inheritance, or maybe, he's super wealthy and said, I don't want anything. The trust is the distribution document, even if it does wind up going into, that asset goes to probate. So you want the pour over will that's in it, which is part of it. Follow up quick?
But that's the only will.
Yes. And if you're married, you each get your own separate. I'm going to keep answering questions. You're next, but I'm going to run back and get me a water bottle. So go ahead.
So what I'm hearing, everything you want to put in there, you will into like this percentage, maybe made up the paperwork, to say in trust, correct?
Yes, we would advise it's always best to make the trust either the owner or the beneficiary. You want this to be the distributing asset, or I should say document, because this knows everything we want. We took time to discuss, and what if she's not there? And then where would her share go? And would it go to her kids, and at what age? I mean, all those things have been discussed in here. Why not let this be the distribution? So yes, we would recommend it. We will walk you through, here's what you should do, but we can't make you do it, nor do you want us to make you do it. We're going to advise you, this is the best way to do this account, or this account, or this account.
So beneficiaries can actually be done online?
Yeah, every account's different, every company's different. Like say you have some money at Merrill Lynch or something, call your broker if you have one, say, do you have a change of beneficiary form? And they can send it to you and fill it out. Or sometimes, I did one online. Basically, you put the name and the password, and then I'll do the drum, click, the little code or something. And then beneficiary changed. So yeah, it's not that hard, but we'll walk you through that. I should say that our clients, we give them advice and counsel. Yes. Yes, sir, in the back. Great question. It depends. You need to assign, if you have an asset like an LLC or a corporate structure, that should be assigned to the trust if it owns assets, right? You can have a business that doesn't own assets, just an account, but anything that owns assets like a rental property that's in an LLC is a limited liability structure so that you can't be sued for everything, just what's in there. But anyways, we would assign the LLC to the trust, and everything in the LLC is now in the trust. You don't have to retitle each property. Once we assign the LLC, everything it owns, and let's say you use it as a holding company and you buy and sell homes and flip them, once the LLC's in, you just buy it in and out of the LLC, that's all covered. So we'll walk you through all that. Good. Yes?
You mentioned that you put trust as the owner, right? Whether it's house, whatever.
Yes.
But things do change after several years once you create it.
Uh-huh.
This. As long as you buy new things and it's in the trust,
Right.
you have to update the trust.
Not really. The trust, people say, well, and some will tell you, come back to my office in a few years, let's discuss. If nothing's changed in your life and the law hasn't changed, the trust is still doing what it's instructed to do. No. They don't change the rules a lot about this. You know why? Everybody in Washington and everybody in Richmond have trusts. All the politicians have these. So they're not changing this much. The last big change that you would need to get your trust updated, required, was 2003 when the HIPAA law came in, and the trust needs to do that. So, we contacted all the clients that had the prior and updated their trust, but since then, no. Now the tax thing's gonna change. What is that gonna be? Here's an advantage that you may not need, but you may need, I don't know. I mentioned that the federal exemption is 12 million today. Who knows what it's gonna be when we die? They're talking about it expiring and then becoming 3 million. They could drop it to 1 million. Then anything over $1 million would be taxed. For a married couple that makes a joint trust while they're married, they get to double the federal exemption. So for my wife and I, it's now 24 million. Well, that doesn't really matter, 12 or 24, but if it drops to $1 million, anything over $1 million would be taxed, not with us, because we would double that. So a married couple doing it while you're married, not after death, after one dies, when you're still married together, making that, you do get another exempted amount. It may or may not benefit you, but it's a benefit. In the very back, yes, ma'am. And then I'll get you next in the green. Sweater.
Decide to do business with your firm, how many attorneys do you have and how do we get assigned to one?
Okay. I promised them this is not a selling event, but I will answer questions, so I want you to know. And anybody interested in following up, I have business cards here. So the reality is we have a couple of great attorneys in Virginia. I don't want a million of them. I want some really good ones, and I want them to be consistent, and I do. And basically, you would work with one of our attorneys. We have a guarantee that says after you've talked to the attorney, if you're not happy, we give you a full refund, and you can seek somebody else. That's after you've talked to the attorney. So we let every client have that consultation. At that stage, you're either happy or you're not. And if you're happy, great. If not, feel free to go on with no harm, no foul. That's what we do.
Just reassign us to another attorney? We didn't like the first one?
You could try the second one. If you don't like that one, find somebody you like. But we're being very generous to say, we'll let you go that far. Talk to the lawyer. If you're not happy, try the other lawyer. If you're not happy, here's your money. But the truth is, everybody loves their lawyers. So we do a good job at this. But you have to decide that. Everybody's an individual. So we're here to help. Green sweater lady, I'm sorry. Don't know your name.
Spouse that dies, and so say you yourself can have $12 million federal exemption, but when your spouse dies, you can file for something called portability.
Yeah, it's a portability, right? So you can swing that over into the trust.
His exemption.
Exactly. And it,
Like following up on what she just asked before, how do you, if I recall your office, how do you go about assigning a person to me? Is it a receptionist that answers the phone?
no, I have a staff. It's not just me, and we have lawyers. And what we've tried to do, and why we can do this for less, is we're looking at this as a company, and lawyers charge for every dick. We don't. We love to talk to our clients, even if we haven't worked with you for years. The benefit is we get a lot of referrals. People like this, they have access to us. They got a question, I want to know this, or how does this work? And I'm thinking about this. Call us. That's a nice thing. You're not wondering about your trust. I don't understand this paragraph here. We'll explain what that means. What we do is basically, if you want to know the process, is anybody that's interested to follow up, my email, daniel@AmericanFamilyEstatePlanners.com. I will send you a list of all the things that it covers. We send you a digital brochure that has the lawyers' profiles and their names and all that. They're real people. They're real lawyers with offices and all that. And then what happens is we send, as the lady asked earlier, what are the questions I'm going to be asked? We're going to send you the questions in advance so that you're looking over all the details. We're going to have a brief conversation before the lawyer to go over that to make sure you understand the questions. And if the lawyer needs to know, you have a son in jail, how do we deal with that? We're going to, we want to know details a little bit. And then it goes to the lawyer, and the lawyer, you have a conversation. That's between you and them. We're not involved in that. The lawyer does it. And then the trust is made, and then we set up a time to sign it. So, which of the two lawyers you'd get, I don't know. Who's busy, who's not. They're both great. So.
I have a question going back to what you talked about with being on, like if I were on my parents' property and they got sued for something that would come after me, could it come after our trust as well? You know what I'm saying?
No, if you and your mom own a property together, she's half owner, you're half owner, it's not in the trust, it's in each other's names, so it wouldn't affect the trust assets. No, that's outside the trust, it sounds like, yeah. The trust isn't the owner, you and your mom are, so that's a different scenario. No. It would affect your mom's estate if you got into an accident. It would affect your estate if, but the trust would be not a part of that. Yeah.
So when does the expense kick in after you call and you talk to somebody and they send you the information that you need to give you? When they do the trust?
Okay, these are questions that were asked. I did not throw them. Basically, we send you an application so you can see everything that you're going to get and the price. You're not going to do anything without, we're not going forward till you know what you charged. And we charge just a little over $2,000. So what happens is that's it. It's $150 per property or LLC, and assignment's $150. So that's this doing the paperwork for you. So you just go, sign. And then we go to the county recorder. So you fill out the application saying, yes, this is what they're going to do and this is what it's going to cost. Okay, so, and I'm going to get a lawyer. Great. Then what happens is we send you the questionnaire, and basically you can do it online. I got 2 kids, and I'm giving them 50-50, and I'm giving some money to this. It's basically a little worksheet, kind of. You can do it online. It's not the final product. It's just a worksheet, right? And then we get that. We go over that with you briefly. Then you talk to the lawyer about it all. Once you're done talking to the lawyer, we're putting all this in formats and stuff. And then we email you a summary. It says, here's what you told the lawyer, double check it to make sure there's no spelling errors, the right people are in the right spot, and then we make an appointment to sign. That's the process. What we typically do is when you've seen the application do it, you could put it on a credit card or write a check. We always give you 7 days to think about it after you've put your money down, and then we give you till after you've talked to the lawyer to complete it. I'm going to just leave these here. Anybody wants a card? Yes, thank you. It's just a tried and true method, but it comes with everything that you've seen on this page here. Anybody else? Yes.
If you already have a will and want to make a trust,
Yes.
how do you negate that?
You don't have to. This trust will have language that says all previous wills and codicils are rendered null and void at the signing of this document. So you don't need to call your old attorney and tell them, hey, throw out that old, because here's what very, very often happens is people get a will, they find a lawyer, and he tells them, yeah, I'll do a will for you. And they get a will. They look at it, they sign it, the notary notarizes it, they make a copy, and they hand you the copy. The original of your will goes into a file cabinet with all the other wills, and when you're not around, he calls that his retirement account. Every morning, the secretary from the law firm comes in, starts the coffee, opens the newspaper, and what section does she turn to first? Obituaries. It's called a client search. Ever done a word search? Anderson, Garcia, Johnson. Oh, we got a Johnson. I thought he looked familiar. Out comes the will. They call the executor, make an appointment to go to probate. The will triggers a probate. Trust does not. Wall Street Journal did an article. Why are people, I do this all over. I was doing it at Reston once about 8 years ago. And this lady at Reston said this, Daniel, I'm new to all this. This is really interesting. She goes, but based on all of this, why is anybody still going with the will? That was her question, right? And I said, well, I can't tell you why people do what they do, but let me tell you this. Most people do not know that the will still goes to probate. They don't know that the will is not binding. It is a set of instructions, but it could be changed and contested. They also, they don't know that. So there's an article here from Wall Street Journal. It talks about the will-pushing lawyers that are pushing wills. Here it is. Come on, Danny. You got it here somewhere. Well, I can tell you what it says. Here it is. Revocable living trusts become popular option in estate planning. And then tells you why they're popular. But then it says, be aware many attorneys do not go out of their way to bring up a trust when a client comes in for a will. It says these attorneys would rather take your $800 or $900, write you a will, and then it says, then meet the rest of the family in probate where they make half of the probate fees. I did not write that. Wall Street Journal wrote that. So they're just saying, a lot of times people get talked into the will from the attorney who somehow has some reason that a will is better for you. But he has a trust, but he'll write a will for you today. Yeah, that's sad. There are lots out there like that just fill those drawers full of wills and they make out in the probate side. We've tried to get attorneys in different states and we say, hey, am I out of cards there? Oh boy, trust me, I got some more, and I got some more. And those that have the brochure, it's the same information on there. I got more.
Thank you.
You're welcome, thank you. You got one? Awesome.
Yeah, I need one for my daughter.
Yee, man.
I'm going to make sure she knows. I appreciate it.
Sure.
Great lecture. Appreciate it.
Thank you.
Thank you.
Please do. Thank you all. I mean, I'm here to answer questions. I'll stay as long as you want till Pastor, Kelly kicks us out, but I'm here in the meantime. Oh, thank you. Thank you. Yes.
Do you have any more sheets?
Last time I was here, only 30 people showed up. Hey, my website is on the card. On the business card is my website. All of this is on that website as well. So, yes. And also, if someone, oh my gosh, no, don't tell me. I didn't bring enough cards too. This is just a crime. Oh, wait. Oh, here's some more. Yeah, there's 10 more. I hope, man. You're so welcome. So glad to help you. Woo. here's some more. I found a bunch more. Oh, okay.
Thank you so much.
You're welcome. Thank you.
Did you get it written and then you want to make changes to
The document?
age my daughter?
Sure.
Something, what's the process?
Again, if you're in the legal plan, there's no charge. The first year is free to make changes. After that, if you choose to stay in the legal plan, there's no charge. However,